You introduce yourself, tell us your name and DOC number.
My name is Edmond Chaisson. My number is 359145.
All right, sir, and I think you're represented by counsel. Would you introduce yourself for the record, sir?
Yes, my name is Jeffrey Smith, and I am the attorney and have been the attorney for Edmond Chaisson since his arrest.
Okay, thank you. And we also have your mother, Ms. Warren Chaisson, who would like to speak, and we'll ask her to do so at the appropriate time. Is she with you, Mr. Smith?
Yes, she is sitting next to me at my office.
Okay, good. So, Mr. Chaisson, you're accused of violating the conditions of your parole. I'm going to read the allegations against you. I'm going to ask you to enter a plea of guilty or not guilty. We'll have a conversation about that. Then we'll hear, once we finish with our questions, we'll hear from your mother. You'll be allowed to make a statement, and then we're going to turn it over to Mr. Smith for his presentation before we vote. Okay? You're accused of violating the conditions of your parole, specifically condition number 4, and it states you engaged in criminal activity on August 16, 2023, when you committed the crimes of domestic abuse, aggravated assault in possession of a firearm, or carrying a concealed weapon by a convicted felon, as evidenced by your arrest by the NOPD August 28, 2023. On November 30th, 2023, you pled guilty to aggravated assault with a dangerous weapon and illegal carrying of a weapon. How do you plead to violating condition number 4?
Not guilty.
Okay, then there's condition number 5. You had in your presence or control a firearm on or around August 16, 2023, when you committed the crimes of domestic abuse, aggravated assault in possession of a firearm, carrying of a concealed weapon by a convicted felon, as evidenced by your arrest by NOPD on August 28, 2023. How do you plead to violating condition number 5?
Not guilty.
All right, sir. You want to tell us what happened?
Me and my girlfriend had an argument. I gave her some money to purchase an automobile, and when I went to purchase it, she was supposed to put the cash on the debit card. When I went to purchase the automobile, the debit card didn't work. When I brought it back to her, she just went ballistic on me. When I told her the money didn't clear, she went ballistic on me. At that time, I called my mother and I just left the scene. Now, prior to that, me and her been having, we was on rocking conditions. But, that was it. I left the scene.
Well, but you pled guilty to aggravated assault in carrying of an illegal weapon. What was the weapon?
There wasn't no weapon. I never got the weapon. I took the charge because due to my lawyer and the parole officer said if I take a misdemeanor, I can go home. But I never got caught with a weapon.
Yeah. Well, you shouldn't have pled because the information you were provided was inaccurate. So how long have you been in jail?
7 months.
7 months. And the complainant or the victim in this case is Samantha Massey?
Yes, my girlfriend.
And she claims you fired a couple of shots at her.
Right.
All right. I tell you what, I don't see any other questions, so we're going to hear from your mother, Mrs. Warren Chaisson. We'd like to hear from her now.
Ma'am?
Yes, sir.
I think I can clear up so much. The mother is to talk about in the event that he was put on parole, he would live with her. But I have so much more information about this case that I think is really important.
All right. Well, we'd like to hear from you then. Now's the time.
Okay. So this case, he was arrested. And in fact, I went to the home with the police because they had a search warrant to look for a weapon. No weapon was ever recovered. There's been no evidence of a weapon. When it reached Section L, right from the get-go, the DAs were trying to say that this was a very weak case, wouldn't give me the total information. So I went and talked to Pierre Hardnett, and I said to him, the state doesn't want to prosecute him for these charges. What can we do to resolve this as quickly as possible to get him home? Pierre Hardnett told me, and he won't deny it, he said, any felony conviction will get his parole revoked. Any A-N-Y, any misdemeanor, we will not revoke him. So I went to the judge, Judge Harris, I went to the DA, and I told them exactly what Pierre Hardnett told me. And they said, that's not a problem because we don't think we can really go forward with this case. We'll give you a misdemeanor. So I called Pierre Hardnett. I said, he's going to plead guilty to a misdemeanor. I asked him, does it matter what it is? He said, as long as it's not a felony. So, and I don't think he was doing this with any malintent. I think that's what he thought was the truth. So I went back to them and they said, we'll give him a $14.95, a possession of a firearm. That's it. And I told them he didn't have a firearm. And they said, well, if your information is correct, he'll stay on parole. The judge wants to give him probation. And I sent all of you, I emailed it to you, the actual plea, which was not really on the 30th. It happened 2 weeks later because the judge changed everything. So the judge said, I want to put him on probation 6 months, and I want him to do inactive probation, and I want him to do drug and alcohol treatment because I think he needs that. So everything was fine. We did the plea. She said, I want him to come back in 2 weeks so we can discuss his probation to see if he's enrolled in inpatient, outpatient, whatever we need to do. And everybody was left very happy with the situation. I called Pierre and told him, okay, I got the misdemeanor. It's done. When does he get out of jail? Pierre said it might be a few days. Then Pierre called me back and said, I'm sorry, Jeffrey, I had the wrong information. Apparently a misdemeanor would have been fine, but this was a gun. And so that's almost like a felony and they want to do a parole hearing. And I was, I've been doing this 43 years and I've never had this happen to me before, but I felt terrible because I could have just gone to trial. And I think very confidently from what I've talked to the DA and the judge about, I could have waived a jury. He would have been found not guilty. But I told the judge right after this happened, what happened. So the judge actually told me, well, what's the problem? I said, well, one of the problems is when he did the plea, he actually was asked, are you pleading guilty because you are guilty? And so that could be used against him. And he never had the gun. So she said, file a motion to withdraw the plea. I then filed a motion to withdraw the plea. And you have the whole transcript in front of you. And then I went back. And if I'm looking right now, in fact, the plea was done on 11/30. And then I filed my motion to withdraw the plea. And we went back on 12/11. And on 12/11, he did a second plea. And I'm looking at the transcript on that. And in that case, the judge said, we're going to do the plea under Alford versus North Carolina, where it literally says, you're not pleading guilty because you are guilty. You're pleading guilty because it's in your best interest. And so it even started off with the judge said, we're going back, entering pleas to the same counts that you did last time. And then she talked about Alford, and she actually said, and you've had a conversation, this is the judge speaking, you've had a conversation with your attorney about conversations that he had with your parole officer. Is that correct? Yes. And it was your understanding that if you pled guilty to misdemeanors that you would not be revoked on your parole. Yes. And you're entering pleas of guilt to these charges because it's in your best interest. Yes. And it goes on and on where the judge keeps and she says on page 7, and on the new plea form, there is something that is written on the bottom. Did you write this? Yes. And in the bottom, it says, this plea is taken under North Carolina versus Alford. Mr. Chaisson is not admitting guilt. He is pleading to 3 misdemeanors because his parole officer, Pierre Hardnett, told his attorney that it would be violated only for felony convictions. and that this would be a technical violation not resulting in revocation. The judgment factor relied on this information in requiring Mr. Chaisson to enroll in an outpatient drug and alcohol program. And then did you sign that form? And the judge did say, just to be clear, no one assured you that you would not be violated on your parole if you enter the pleas today for the 3 misdemeanors. And, you know, he said he understood that. And so the bottom line is he would never have pled guilty to anything had we thought his parole would be violated. And I, what can I say? 43 years, I talked to parole officers, I don't know, hundreds of times, and this has never happened before. If Pierre had told me, Jeffrey, any misdemeanor involving a gun, then we would have just said, we're going to go to trial. And from my talks to the DA, eventually this case would have just been no pros. However, we wanted to get him in home. He has a job. His boss was keeping his job open for him. I sent a letter to you also, which you should have in front of you, from Damon Gibson. He's an electrician, and he has offered his same job as an electrician. You know, this is the first time I can say in 43 years, I relied on the parole officer's information. Had he told me from the get-go, it never would have happened.
Can I ask you a question?
Yes, sir.
Okay, why didn't you let him withdraw his plea when you went back in December?
I did.
No, the judge told you at the end that he could be revoked, and he said he understood.
Because we all felt that the best thing to do was simply say that it was in his best interest to plead guilty, but not because he's guilty, under Alford versus North Carolina. And if we would have waited and gone to trial, just telling you from my experience in the building, it might have been another year before we would have got to trial. It's just, I mean, I'm trying cases now that are 3 years old. So to get him home would have taken probably at least a year to have a trial. And so the fastest way we thought would be to just enter. And let me say this, the district attorney made every representation that the alleged victim did not want to testify. And I believe it's because she didn't want to perjure herself. I didn't make a big deal about it, but I didn't want her to have to go to jail for filing a false police report. They never found a gun. There was no evidence I never saw ballistics of a gun fired. I didn't see any of that. So, and when I offered the misdemeanor, they immediately, and if you look at the docket master, they jumped on it. They literally, and trust me, I do this every day I'm in that building. I know every judge, every prosecutor, had they thought that a weapon was used, they never would have so quickly offered a misdemeanor, and then had no objection to redoing it again, where he then officially said, I am not guilty. I'm pleading guilty because it's in my best interest.
Okay, Mr. Smith, thank you. We definitely hear your message, and I'm going to make a motion that we go into executive session to discuss confidential matters. All those details that you just mentioned to us were obviously a late submittal and just uploaded this morning to our records. I have not had time to look at them. So stand by, we'll be there in executive, well, I need a roll call executive session. So we're going to go in.
But can I just tell you one thing really quickly? I had emergency gallbladder. This all would have gotten to you last week.
I'm sorry, sir.
But I was operated
Mr. Smith,
on.
we'll be in executive session for a few moments to discuss confidential matters. All right, we are back in regular session, and thanks for your indulgence. We had to have time to review the documents. Mr. Smith, Mr. Chaisson, we are prepared to vote, and Mr. Freeman's going to be voting first.
Okay, Mr. Chaisson, we're looking at the file. And I know there was a lot of stuff that went on between the probation officer, your lawyer, the judge. But the final thing the judge tells you is that these counts can be used against you for your revocation. That's the final thing he said. When he said that, your head should have picked up, because you pled to some charges which we cannot ignore. They're violent misdemeanors, and I choose to revoke it this time.
Mrs. Ledoux.
Mr. Chaisson, looking at the total package of your time on supervision, I wasn't pleased with not seeing some things that you were mandated to do by the parole board. That's not the reason for my vote today, but I just want to make sure that you know that there were things you were supposed to be doing. But the police report gave me concrete evidence that that you have violated your conditions. My vote today is to revoke.
All right, Mr. Chaisson, and I do concur with my colleagues based on the information contained in the police report. My vote today is to revoke your parole. All right, sir, we wish you well. We'll send you information on how you can apply for re-parole and instructions on how to do that.